Hi, thank you for joining us this evening, December 10th, at the City of Carlsbad Housing Commission meeting. We are, this is our regular meeting following a special meeting we had about the housing element, and we will do our roll call. We're going to forego the Pledge of Allegiance because we don't have an image of the American flag for that, so we'll go straight to roll call. Ms. Crescenti.
Commissioner Shirley Cole.
Here.
Commissioner Marissa Cortez Torres.
Here, sorry.
Commissioner Joy Evans.
Here.
Commissioner Alan Manzano.
Here.
And Chairperson John Wynn Cleary.
Here.
Five are present.
Thank you very much. And I'd like to introduce our Housing Services Manager, Mr. David De Cordova, to introduce himself and staff and any consultants joining us on the call.
Thank you, Mr. Chair. My name is Dave De Cordova. I am the Housing Services Manager, and I am joined by Nancy Melander. She is our Program Manager. And this evening she'll be presenting to you. She'll introduce you to the folks at Legal Aid Society of San Diego, who will be providing the fair housing training this afternoon.
Great, thank you very much. We will have non-agenda in a moment, but I just want to explain for anyone who's watching that if we have public comment either now or later, that when read out loud would run longer than 3 minutes, which is the limit if we were having an in-person meeting, that we simply stop reading at the 3-minute mark. Of course, to complete a sentence, but if you hear what sounds like an incomplete thought, it's because we're observing the city's 3-minute rule. Ms. Crescenti, do we have any non-agendized public comment?
Yes, we have one non-agendized comment. I will go ahead and begin reading it. This comment is from Diane Rivera. Dear Mr. De Cordova and Commissioners, thank you for a special Housing Commission meeting on 10/3. For considering my comments below to assist you in drafting a uniform affordable housing department, along with policies and procedures to assist affordable housing applicants in the City of Carlsbad. My thesis, City of Carlsbad's affordable housing availability and the barriers encountered related to the application process for some affordable housing complexes are many. My project, Finding Senior Housing, notification of new or available units do not exist. My challenge, how to obtain affordable housing. My discovery, difficulty in navigating the paperwork, not straightforward process without a consolidated citywide department, policy, procedures, and documentation process. My application process is not universal. It's not universally understood by all applicants and complexes. Transparency for affordable housing in the City of Carlsbad is needed. Inability to get what is required to rent a unit for an individual from an affordable housing complex, either at the pre-application process or at the time of full application in writing. Inability of individuals to meet affordable housing requirements due to a lack of full disclosure regarding how to budget a resident's monthly income and expenses accordingly. Related to building affordable housing complexes, how do the funding sources for building affect those who may qualify to rent a unit at each funding level, if any? For instance, tax credit funding, equity, partial funding, public-private funding, funding from the City of Carlsbad, other federal, state, county, and/or local funding. An example, how and why would a Roth IRA savings account impact one's qualifications for rental of an affordable housing complex unit? What federal, state, county, or local law that would legally protect a tenant from losing their affordable housing unit? Relative questions regarding barriers to renting an affordable housing unit. When does an individual receive adequate information protections in writing backed by federal, county, and/or local policies regarding a given rental situation? I.e., I was told that if I go over a specified amount based on the AMIUs, I would be asked to vacate. How does an individual determine what amount and when of their retirement accounts of their assets or any other asset is counted towards their monthly income to qualify for a rental opportunity as defined by the application form. That is 3 minutes. You have been emailed the rest.
Great. Thank you very much for reading that into the record. And as our commissioners know, we're not permitted to deliberate or take any action on non-agenda items, but I will briefly comment, if Ms. Rivera happens to be listening to this recording, that we will take record of this and share it with our housing staff, of course, through Mr. De Cordova and company here, and also want to comment that multiple commissioners, and especially Commissioner Evans, has raised many of these issues with our housing element, and that the response from the city has been positive, and that we do anticipate the addition of a new objective within the housing element that specifically requires that the city, during the planning phase after its adoption, address these issues of notification, transparency, navigation, and discovery. So thank you very much for your public comment. With regard to the agenda, I skipped over one thing for those who are keeping score. Approval of the minutes. We do not have any minutes for consideration at this meeting. We did have a special meeting a week ago today, and the minutes of that meeting are not ready yet for our consideration, and that will be viewed at our January meeting. We'll move on to the new business item of fair housing and eviction moratorium training, and we'll turn it over to Ms. Melander.
Thank you. Good afternoon, commissioners. I'm Nancy Melander, the Grants Program Manager with the city. With us today, we have the Legal Aid Society, the city's fair housing provider. They will be presenting a training on fair housing basics, tenant and landlord protections, and some of the recent updates to the law due to COVID. But before I pass it on to the Legal Aid Society, I just wanted to let those that are watching through the live stream know that if there are any questions in regards to this training, questions can be sent to the city's website at housing@carlsbadca.gov, and we will get to them. During moments where there are moments of natural pauses and breaks, we will try to get to those questions. With no further ado, I would like to introduce Danielle Tallert and Lila Gitasanti, and I would like to pass it off to them. Thank you so much.
Thank you so much, Nancy, and thank you for letting us join you all today. I did want to share my PowerPoint. Am I able to do that?
I don't have a picture.
We certainly hope so.
Okay.
It needs to hit the end of the bottom. Yeah, there she
There
is.
we go.
Right.
Okay, so hopefully you can all see my PowerPoint. My name is Danielle Talliart, and I am one of the attorneys on our fair housing team here at Legal Aid Society of San Diego. And I just wanted to go through a few things with you all today. So one is going to be what are fair housing rights? Not a lot of people are aware of them and what that means. And then also know who to contact about this if you feel like your fair housing rights have been violated. And so the first step is to know what is fair housing. Fair housing kind of boils down to housing choice. So people with similar income levels and the same rental market should have the same range of choices available to them despite their protected class status. And just in a moment, I'm going to go over what protected class means and what those are. But again, it's about choice. So someone who has the same income level and same qualifications as anyone else should have the same options and choices of areas they want to live in and rental units or homes they want to purchase. What is not fair housing? So the first one is going to be landlord-tenant disputes. A lot of times this is going to fall into housing law, and that's not to say that there is not a remedy or protections for these landlord-tenant disputes. It just may not fall into fair housing. So this is going to be things like asking for repairs, paying rent, maybe receiving a notice from the housing provider, things like that, most of the time are going to fall into housing law. A caveat here is unless the actions by the housing provider are motivated by your membership in one of the protected classes. So for instance, if a housing provider, because of your protected class status, then it would fall into fair housing. So there is some bleed over there, and sometimes you may have remedies in housing law and fair housing law. And then also affordability issues. These are not considered fair housing. There's no specific fair housing protections around that. So we have federal protected classes, and then we also have state protected classes. But the federal ones are going to be race, color, national origin, religion, familial status, sex, and disability. A couple of notes on these is that familial status essentially just means the presence of a biological child, adopted child, foster child, grandchild, or some other child that you have been appointed legal guardian of. So essentially, it's just the presence of a child in the household. Sex also includes gender, and we see a lot of reports of sexual harassment, which would fall under this category. And then also a note on disability, that can be a mental, physical, or developmental disability. So in California, we have some additional protected classes. So California incorporates all of the federal protected classes and then added some more. So race and color, that's also technically two different protected classes, but they're often alleged together. There's also ancestry and national origin. So ancestry is a state protection, national origin is a federal protection. And one note under here is that this can include your primary language. So if your primary language is not English and someone refuses to give you a rental application or give you a tour of an available unit because English is not your primary language, that would fall under this category. Religion is both federal and state, and this includes all aspects of religious belief. So this is also going to include observance and grooming. Disability, like I said, is mental, physical, and what's missing from this list is also developmental. Sex, as I mentioned, includes gender, but it also can include pregnancy. Sexual orientation is state specific, as well as age. Gender identity and gender expression, these are also state specific. Marital status, this can include being married, not being married, divorced, or separated, but this is state specific. Familial status, what we're looking for are maybe rules that specifically seek out children or single out children and are overly restrictive. We had someone call in because their apartment complex had a policy where anyone under 14 years of age had to be accompanied by someone over 18 anywhere within the complex. And so that prevented someone who's 14 from being able to go check the mail or something like that. So that's just overly restrictive. A caveat here is that there is an exception to that if it is for the health and safety of everyone. And so the most common example is going to be a pool. So children are going to have to be supervised. Also, housing providers aren't able to ask about children or refuse to rent to you because you have children. And then also overly restrictive occupancy standards. So in California, we have this general rule of what we call 2+1. So that's 2 people per bedroom plus 1 in a common area. So a 1-bedroom unit could have 3 people. And so sometimes we see housing providers limit that where, you know, they say a 1-bedroom can only have 1 person or 2 people. And so we see that sometimes. There are also other anti-discrimination laws in California. One of UNRRA, also called UNRU, and this includes citizenship, primary language, and immigration status. So someone cannot inquire on the status or disclose citizenship status with the purpose of harassment or intimidation. But, a housing provider can still request information, on the application to verify financial qualifications or perform a background check, things like that. Source of income, I'm going to go over this in more detail in a few slides. So I'm going to skip over it for right now, but there has been an update as of this year. We also have military and veteran status. This is new as of January 2020, and this includes active and reserve. We also have arbitrary, and this is kind of a catch-all category in California. And this also now includes citizenship, primary language, and immigration status. And you might think, well, isn't that covered under UNRRA? It is, it's two different laws. And so it could potentially be two different violations. So these are the acts of discrimination that are prohibited. And so when we're looking at fair housing violations, we're looking to see if the housing provider took an adverse action against you because of your membership in one of these protected classes. So these are the things that they're not able to do. The first one is refuse to sell, to release rooms to you, represent that a unit's not available when it really is, deny a home loan or homeowner's insurance, offer inferior terms, conditions, privileges, or facilities. Sometimes we see this, especially with folks that have vouchers or rental subsidies, where some housing providers will try to limit someone's access to the common areas or the amenities at the property because they have a voucher or a rental subsidy. So that's not allowed. We do see that from time to time. The next one is refuse to permit at a disabled tenant's expense a reasonable modification when necessary to accommodate a disability. And then the next one kind of goes along with that, where it's a reasonable accommodation request. And I'm gonna go into those in a little bit more detail. So I'm gonna not go too much into detail right now. So I'm gonna kind of skip over those. And then the last one is retaliate against someone for filing a complaint or asserting their rights. So these are just some common fact patterns that we see. The first one is a landlord refuses to rent you an apartment because you need a ramp. So this would be, someone who uses a wheelchair, maybe there's a step up into their unit or something like that, and they need a ramp. This would be a reasonable modification. And so a housing provider couldn't deny application, or deny them the rental unit just based on the fact that they need a ramp. The next one is a landlord refuses to rent a second floor unit to a family with children because the kids may hurt themselves or steers them to the back of an apartment complex. So again, fair housing is about housing choice. And so in this example, the housing provider is limiting a family with children from all of the available units. So can't do that. Next one is a landlord refuses to rent you an apartment because you have an emotional support animal or a service animal. So also can't do this. Even if there is a no pet policy, the tenant or the applicant could submit a reasonable accommodation request to have an exception to that rule. And again, I'll go over that in more detail. So disability is the #1 complaint received locally, but also nationally. So the disability, the protected class is a little bit different and is treated a little bit different than the other protected classes because folks with disabilities have the right to be actually treated differently if necessary to use and enjoy the housing and if it's requested properly. So a reasonable accommodation is a request for an exception to a housing provider's rule, policy, practice, when necessary to afford a person with a disability an opportunity to use and enjoy a dwelling. And I'll be going over some examples for these as well. And then a reasonable modification is making a physical change. And this could be inside the unit, outside the unit, or even in a common area. And a note here is that if the housing provider receives federal funds or federal financing, it's actually the responsibility of the housing provider to pay for and install the modification. If it's private housing, it would be the tenant's responsibility to do that. Okay, so how does someone make one of these requests? So first, and this can be done by the person who has the disability or maybe an authorized representative. Potentially it could be like a case manager, social worker, family member, someone like that could also request it on their behalf. Writing is not required, but we definitely do encourage it. We find that this eliminates a lot of miscommunications, that sort of thing, when communicating with the housing provider. No magic words are needed. So someone doesn't even have to say the words reasonable accommodation or reasonable modification. But what a housing provider should be listening for is someone saying, you know, I have a certain disability and I need this change, or I need an exception to this rule. And that should trigger this kind of analysis and this interactive process. Medical verification. So this one can get a little bit tricky. If the disability is obvious and the disability related need for whatever they're requesting is also obvious, then actually the housing provider cannot ask for medical verification. So going back to the example where, you know, someone who uses a wheelchair needs a ramp, that's going to be obvious. And so the housing provider would not be able to ask for verification. But if the disability is not obvious and the disability related would ask for some sort of medical verification. The housing provider must consider the request and must enter into what we call an interactive process in a timely manner. So this means that once the request is made, this line of communication should be opened between the tenant or the applicant and the housing provider. The timely manner, there's not a specific deadline, something like that, where this has to be completed by. It really is on a case-by-case basis of what the person's requesting. There may be some sort of timetable attached to it, or maybe the request can't be accommodated. You know, for instance, if someone asked to transfer to a different unit, you know, maybe there's not another available unit. And so the request may take a little bit longer, but just I would recommend keeping the housing provider and the tenant updated. They each should be, you know, just communicating with each other. There's only a few reasons why a request can be denied. So the first one is going to be if the person's not disabled. So if the person's not disabled, then they're not entitled to request a reasonable accommodation or modification. The second, but there's no nexus. There's no clear connection between their disability and what they're asking for. That could be another reason for denial. Just a side note to housing providers, if that is what you think is happening, that there's no nexus or connection between the disability and the request, I would ask for some sort of verification to explain that, and maybe there is a connection. The next one is the accommodation would cause a change in services. So this is what we call a fundamental alteration. An example of this would be, you know, maybe someone is disabled, able to drive, and they ask the on-site manager to give them a ride to the grocery store. Well, maybe they are disabled, maybe they do need that service, but that's going to be outside of the services that a housing provider provides. The next one is undue financial and administrative burden. I will say it's hard to give an example for this one because I actually have not seen this argument be successful. But one example that I thought of would be, someone with a disability lives on the second floor, but it's difficult for them to walk up and down the stairs. And so they ask for the housing provider to put in an elevator. Well, maybe disabled, maybe an elevator would really help them, but putting in an elevator is going to be a huge financial cost. So at that point, I think it would be a burden. The last one is if it poses a direct threat to the health and safety of others or the property. One example of this would be if someone asked to knock down a load-bearing wall. Well, that's going to be, that's going to affect the safety of the unit and the habitability of the unit. Another would be, we see this sometimes with animals. So if someone has an emotional support animal or a service animal, if that specific animal poses a direct threat, then they can be asked to remove the animal, but it can't be conduct of that specific animal. So here's some common examples that we see. Requests for an assigned parking spot at a first come, first served complex. So maybe someone has a mobility disability and they need an assigned parking spot close to their unit. They would be able to ask for that as a reasonable accommodation, even though there are no assigned parking spots normally. Use of a third party to pay rent. So sometimes we see clients have payees to manage their money and to write checks for them. And so they could ask as a reasonable accommodation for a third party to send in their rent check each month. Economic accommodations, this could be someone who needs a caregiver, and there are guest fees for having someone stay in the unit for a long time. So they could ask as a reasonable accommodation to waive those guest fees because it's for a caregiver. Exception to no pets policy. So I briefly touched on this, but HUD has come out with guidance that a housing provider cannot restrict the breed, size, or weight of the animal. Animal vest, ID cards, or certificates. So unfortunately, there are a lot of scams out there. And so one that I see a lot is like a national registry for emotional support animals. That really doesn't exist, and unfortunately, they are successful in that scam. And I've seen some people fall prey to that, but it really doesn't exist. And it doesn't have a bearing on the reasonable accommodation request. Direct threat. So again, if that specific animal poses a direct threat to the health and safety of others, but if that does happen, the tenant should be allowed to bring in a different animal. And then again, the example of installing a ramp or something like that. Another one that we see a lot that's not on this list are installing grab bars in a bathroom. We see that a lot as well. I just wanted to touch real briefly on animals because this is something that we see a lot. And so service animals and emotional support animals are actually treated the same under fair housing laws. The difference comes from ADA law. But a service animal is going to be an animal that has been specifically trained to provide or perform some sort of task for a person with a disability. And then an emotional support animal does not receive any training. And as far as verification for this, the standard in fair housing law is that an individualized assessment from a medical professional has been done in order to say this person has a disability and they would benefit from one of these types of animals. The certifications that are, give us $50 and you can immediately print a letter out that says you need emotional support under fair housing law, because at that point, no individualized assessment has been done. Just a couple of updates for COVID. So at the beginning of the pandemic, back in April, DFEH, which is the Department of Fair Employment and Housing, which is the state agency in charge of enforcing the state fair housing laws, they came out with some guidance saying that if someone is diagnosed with COVID-19, that they would consider this to be a disability, which opens up the opportunity for folks who have been diagnosed for COVID-19 to request a reasonable accommodation or modification. And so the example here is just who may not normally be considered disabled, is diagnosed with COVID-19, and then needs a caregiver to come and stay with them while they recover. So they would be able to ask for that caregiver to come stay with them. We also did see a rise in national origin discrimination during the pandemic. So again, it's just unlawful to discriminate against someone because of their national origin. We also saw some discrimination against older folks. And so we did see some housing providers, and they might have meant well, but they restricted people over 60 or over 65 from accessing different areas of the property in order to limit their exposure, but then that prevented them from being able to do laundry or access mail. And so can't do that because that's restricting their access to the property. And then also, unfortunately, we did see an increase in sexual harassment being reported and also domestic violence. And then I wanted to go over the new source of income protection, and this is statewide. So the source of income protection already existed, and it was this first bullet point was the old definition. And so the old definition was lawful, verifiable income paid directly to a tenant or to a representative of a tenant. And this formed the basis of the protection. And so previously we would see source of income discrimination where housing providers, when evaluating if someone made enough money and had enough income to qualify for a unit, they didn't want to consider SSI or SSDI payments or child support or spousal support. And so they can't exclude those from that income calculation. But January 2020, there's actually an update. And so the state added this second bullet point, or paid to a housing owner landlord on behalf of a tenant. So now this new definition of source of income includes people who receive rental assistance from any federal, state, or local subsidy. So most commonly, this is going to be Section 8 housing choice vouchers. And then also a lot of jurisdictions are providing, short-term COVID-19 related rental assistance. And that would, I would argue, also fall under this source of income protection. And so housing providers are no longer able to say, I don't take Section 8 or no vouchers or no subsidies. So they're not able to do that anymore. And so the goal was to open up more housing to folks who have subsidies or vouchers. And so if you feel like you have been discriminated against, or if you feel like someone who has, feel free to give us a call. This is just some information that a lot of times we'll ask for, like a timeline of what happened, if you have a copy of the lease agreement or any notices, anything you think is relevant, witness contact information. We'll probably ask for all of these things. So if you have it, great. I would have it available when you give us a call. And then also I just wanted to highlight our resources. On the left-hand side is our discrimination or you want to give us a call, our phone number is on there as well. And then also on our right-hand side, our wonderful housing team put together a lot of FAQs about all of the eviction moratoriums, which will be covered in a second as well. But on the website are all of the links to the FAQs and for all the eviction moratoriums in place right now, and we have those in English and Spanish. So that's all that I have. I'm going to turn it over to Layla from our housing team, and she's going to go over some eviction moratorium things.
Let's pause here if we can.
Yeah.
I see you about to speak. Were you introducing the next presenter, or can we take an opportunity now for any questions or comments about this first half of the presentation?
Yeah, thank you. I wanted to thank Danielle and open this opportunity for questions from the commissioners.
Great.
And I haven't received any questions via email, so.
That was my next question. Thanks very much. I saw Commissioner Evans.
Yes. In regards to this, is it a blanket? Let's see, blanket. Does every apartment complex have to take Section 8?
Yeah.
I mean, is that the truth?
Yeah, so there are a few exemptions, and so FEHA, or the State Fair
I don't know
Employment
what
and
FEHA,
Housing
I
Act.
don't know what those abbreviations mean. FEHA and AHU. I don't know what those mean.
Yeah, so FEHA stands for the Fair Employment and Housing Act, which is the state fair housing law. And so there are some exemptions, not very many. One of them that is probably most common is if the owner of the housing lives in the home that they are renting, and they rent to one person. So that's an exemption. There are also a few other exemptions, but otherwise, in the state of California, vouchers and rental subsidies.
Really?
Mm-hmm.
Okay, now is that just in Carlsbad, or is that in the state of California? Or do you know?
That's for the entire state.
Interesting, thank you.
Mm-hmm.
Commissioner Manzano?
I was wondering, there are a number of things that landlords could do. It may, I would like to clarify that may have the same effect in terms of discrimination. For instance, looking at arrest records, or establishing no smoking, no drug use, or looking at proof of current employment and the financial history of the individual with other landlords they've rented from in the past. And these sort of things don't sound within the scope of your rules. And there is another issue that came before the council a while back, which had to do with preferences for housing that are established through actions of this commission, where the commission restricted it essentially to a band of residents coming from Carlsbad to Escondido. And to me, that I did not see that favorably, because the balance of a mix of people here are not necessarily fixed. For instance, I would say that there are very few African Americans proportionately in our area. So could you comment on those?
Sure. As far as the first point, I only covered a few topics within fair housing to fit within the time. And so there are a lot of other more specific things that I could have gone into. So some of those things that you mentioned, like criminal histories and employment and that sort of thing, a lot of those are covered. I just didn't go over it in this presentation. And then as to your second point, at this point, I'm not really able to comment on that, just because I'm not sure what the specific action that was taken. So sorry about that. Can't comment on the second one.
Commissioner Manzano, do you have any follow-up before I move on to another who had their hand up?
No, please go ahead.
Okay. Vice Chair Cortez Torres.
Yes, good evening. Thank you. I did have a question on accommodations. So someone who was disabled has a child that has specific allergies and is allergic to dust mites. Of 99% on the test is allergic to almost everything. The person from the home. If the apartment complex says we're only going to do it for the living room, but the bedrooms have to stay with carpet, is that something they can forcibly do, even though they have a letter that the doctor states that the child is completely allergic, he shouldn't have carpet in the rooms at all?
Yeah, so this is a scenario that we actually see fairly often. And so, no, I would say if the request is to replace all of the carpeting in the unit, because, the child's going to go into the bedrooms, I would say then all of the carpet needs. I actually haven't seen where a housing provider agreed to part carpet replacement and part not. But I would say that all of the carpet should be replaced.
Yeah, the manager stated that that if they wanted the carpet replaced in the bedrooms, that the tenant would have to pay. They'll do the flooring in the living room, but they wouldn't do it in the bedrooms.
Yeah, that gets a little bit trickier because if it's private housing, then
it's Glen Ridge Apartments in Carlsbad.
Okay. So okay, I mean, so if it is federally, and it would be the responsibility of the housing provider to pay for and install the modification.
Okay, and how do you go around that? The person should go to Fair Housing?
Yeah, they can give us a call. Absolutely.
Okay, thank you very much.
Mm-hmm.
Commissioner Evans.
Yeah, you just mentioned if it's federal finance, and when I asked the question, if every apartment area has to rent Section 8, you said yes. Now, does it need to be somehow attached to a federal financing? I mean, if somebody has a 4-plex or a 6-plex, have to take somebody from Section 8? That's what I was getting at.
Yes. So for disability related requests, those are going to be different than other protected classes. And so for accepting vouchers, that does apply to all types of housing, whether federally financed or private.
Okay, well, not just necessarily disabled, just say a Section 8 person. So like a 6-plex or an 8-plex, they still have to take Section 8. They don't have a choice.
Correct. They would have to accept vouchers.
Well, okay, thank you.
Commissioner Cole, did you have anything at this time? Okay, I saw you shake your head. I wanted to back up just a step. This really goes back a bit to the introduction, but to clarify sort of the context of this, does the City of Carlsbad contract with Legal Aid Society of San Diego? And what is the nature of the contract? And can you describe the volume and nature of calls you receive specifically from Carlsbad?
Yes, so we contract with the City of Carlsbad to perform their fair housing services, which includes investigating and representing mostly tenants, but it could also be homeowners within the City of Carlsbad who feel like their fair housing rights have been violated. I actually don't have the numbers in front of me. I didn't prepare those for this presentation. But You know, if someone within Carlsbad feels like their fair housing rights have been violated, you know, absolutely give us a call.
Do you have any sense of, I know you said you don't have the numbers in front of you, but just a general sense of scope is, you know, the calls that you would get from Carlsbad residents in a given year might total less than 25, you know, somewhere short of 100, over 100, just any broad stroke numbers?
So if I could just interject very quickly, I actually do have those numbers.
Great.
Just in fiscal year 2019, the Legal Aid Society served approximately 167 clients.
167, great. And
CDBG funds, that is.
May I say something,
yes,
Commissioner
of course.
Perry? So can you also explain to the commissioners that might not know that there is an income bracket for regular assistance with legal aid, but the income bracket is not the same if you go through legal aid fair housing?
Correct. So there are some teams at Legal Aid that actually don't have like an income maximum, and so fair housing is one of them. So we have no income limitations on our services.
Great, thank you. That's a very important clarification. And also, can you describe what is the nature of the support that you provide? Is it advice? Does it range all the way up to legal representation? And how do you make those determinations?
Yeah, so it can go from advice, investigation, private conciliation, which is just like an informal mediation with housing providers, to an administrative complaint, or potentially a lawsuit as well. So we have a whole range of different services, and it really is just on a case basis on what's appropriate for that particular person.
And if I could add as well, Chairman Cleary, the city also receives numerous amounts of phone calls as well on fair housing issues. So when we get those phone calls, we refer them over to Legal Aid Society, and then they screen the calls and continue with the investigation if there is a fair housing issue.
Great, and I just to go back to the number you gave earlier, 167 cases. Sorry, was that cases, meaning that there was some action taken in support of a contact other than just giving them, you know, listening to them and giving them advice, or was that calls, individual calls?
I believe those are just calls, any type of service received, whether it's advice, mediation, litigation, or a referral to another social service.
Okay, great. Thank
And
you.
John, is the main phone number the number that's on the front, 844-449-3500?
Yes. Yes, that's the fair housing hotline specifically, but if someone also just calls our general Legal Aid Society phone number, they can still get to the fair housing team as well.
Thank you.
Great, thank you all. I think we're ready to proceed to the second half of the presentation specific to the COVID-19 pandemic.
Perfect, thank you. My name is Leila Giti Satani. I'm a staff attorney with the housing team. I'm gonna set up my presentation to share that with you. All right, so I hope you see the full screen and not the presenter screen of the presentation. My presentation is going to be specific to responses to the COVID-19 pandemic, specifically AB 3088 and the CDC moratorium. So the purpose of this presentation, it's meant to provide general information about these laws. The law is rapidly changing in this area. If you have specific questions about your issues or your concerns, please consult with an attorney or the appropriate agency about your rights in a particular situation. You can also contact the Legal Aid Society. I've put our main phone number down. It's 877-534-2524. Or you can visit our website at lassd.org. As Danielle had a screenshot earlier, if you go to our main homepage, summary of a lot of the different eviction moratoriums, including AB 3088, and I believe we recently put up one about the CDC moratorium. They are in both English and Spanish. So starting off with AB 3088, it is the COVID-19 Tenant Relief Act of 2020. It was passed and signed into law August 31st of this year by the California legislature. It provides protections from evictions for eligible tenants for failure to pay rent and other financial obligations under a lease. And it goes back to March 1st of 2020, and it's going to run through the end of January 2021. But in order to get those protections, a tenant must submit a declaration of COVID-19. Cover that in a little bit. This is not relevant anymore, but there was also a stop on the courts were not issuing summons for non-payment of rent evictions until after October 5th of 2020, unless there was a health and safety exception. And the law also temporarily expands just cause protections for all residential tenants through January of 2021. There are increased penalties if landlords illegally lock out tenants, shut off utilities, or engage in other extreme harassing behavior. Masking protections, which are cases are not, eviction cases are not public when they are filed. Those have also been expanded for tenants with COVID-19 related financial distress. So in order to be an eligible tenant for AB 3088, it includes those who have experienced COVID-19 related financial distress, such as a loss of income caused by the pandemic, increased out-of-pocket expenses directly related to performing essential work during the pandemic, increased expenses directly related to the health impacts of the pandemic, childcare responsibilities or responsibilities to care for an elderly, disabled, or sick family member, again, directly related to the to earn income, increased costs for childcare or attending to an elderly, disabled, or sick family member directly related to the COVID-19 pandemic. And number 6 is kind of a catch-all. It says other circumstances related to the COVID-19 pandemic that have reduced a tenant's income or increased a tenant's expenses. And one example of that is I had a call from a tenant who she normally gets a different job over the summer. So that wasn't anything related to the pandemic, but every summer her job ends, she needs to get something else for the summertime, but otherwise she does have a regular employment. So when this summer hit, she wasn't able to find that job that she normally does. Either the place wasn't open or they were not. Even though she didn't lose a job because of the pandemic, she was unable to find income for the summer because of the pandemic. So that's possibly a situation that would fall under number 6. There is an enhanced pay or quit notice for any rent owed during the covered time period, and that is from March 1st, 2020 through the end of January 2021. So while there was regularly a 3-day notice to pay rent or quit, for any rent during the covered time, a landlord must serve a 15-day notice to pay rent or quit. Those 15 days do not include weekends or judicial holidays. That notice must be accompanied by a blank declaration of COVID-19 related financial distress. And again, the tenant does have to timely return that declaration of COVID-19 related financial distress. The notice must also advise the tenant of AB 3088 non-payment of rent protections. If a tenant is what is considered high income, and I will go into that, and the landlord has proof that a tenant is what is in quotes, high income, they can ask for documentation of economic impacts. So there, it's a little bit tiny, but there is a sample declaration. We actually have this sample on our website. If you go to lassd.org on our homepage, there is a summary of AB 3088, and the last page of that summary has this declaration that tenants can use to submit to their landlord. So failure to provide this notice within the required days can result in the loss of your AB 3088 protection. So it's very important for tenants to turn this in. It must be signed under penalty of perjury, and it has to be delivered to the landlord. And there are a few different ways it can be delivered. It can be delivered in person if it's permitted by that 15-day notice. It can be turned in by email, again, if it's permitted in the 15-day notice, via US mail to address indicated in the notice, or using any of the same methods a tenant can use to deliver the payment pursuant to the notice. And high-income earners also have to submit documentation of the economic impact. So published, the official state
Excuse me,
income.
Mr. Chair, can I interrupt for just a second?
Sure.
Yeah, we're having some difficulties with the audio portion of the meeting. And so the audiovisual folks asked if we could take a 5-minute break so they can stop and restart the connection. Would that be okay?
Sure. And do we put ourselves into the holding room or in essence cancel live stream so we are in a holding position, or do we all need to log off and log back in again?
Oh, that's a great question. I'm not sure. Why don't you?
No,
why don't
that
we
should
just
not
take
be
a-
necessary.
Okay, thank you.
Okay.
We'll just thank you.
I have a question that we can ask again in public session, but I'm asking because I may just have missed the answer during the presentation. The declaration of COVID-19 related financial distress, to whom does that go? Did we answer that at the very beginning?
It goes to the landlord.
Oh, okay.
So the
So
tenant has to turn it into their landlord.
Okay, so there's no central authority. All right, so I don't want to pursue that further, but maybe when we all come back, just to clarify again for the public that goes to the landlord, and so there's no one collecting these centrally.
No.
And so if
Declarations of financial distress, as it says here, have to be delivered to your landlord, and there are a few different methods you can turn them into your landlord. One is in person, again, if it's permitted by email, if it's permitted in the 15-day notice, via US mail to the address indicated in the notice, or using any of the same methods tenants can use to deliver payment pursuant to the notice. So this along, then if you are a high income earner, you would also have to turn in your documentation of economic impacts to your landlord. So a high income earner is a household with an annual income of 130% or more of the median income of the county where the property is located. And that's based on what's published by HCD in the state official state income limits for 2020. Generally, it does not include a household with an income less than that a tenant is a high income earner. They can require documentation supporting a claim of COVID-19 related financial distress. This cannot be a fishing expedition. The landlord cannot request that unless they have proof that a tenant was a high income earner. And one way they may have that information is if when you did an application to move into the unit, you likely had to give them your income information. So that might be how the landlord had information previous that you were a high income earner. Some documentation, we have some examples, but it should be any form of objectively verifiable documentation of your income. Something like a tax return, a W-2, letter from an employer or a pay stub from a government agency, proof of court-ordered payments, such as child support or spousal support, proof of regular distribution from a trust, annuity, pension, or other financial instruments. So if you are an eligible tenant, you've turned in your declaration of COVID-related financial distress to your landlord. And again, if you're a high-income earner, you also submitted documentation of your income. There are 2 time periods under the law. There is the protected time period. So that's from March 1st to the end of August 31st, 2020. And then there is the transition time period from September 1st, 2020 to the end of January 2021. So for the rent that's owed during the protected time period, the unpaid rent during this time period cannot be the basis for an eviction. AB 3088 does not relieve you of your responsibility to pay rent, so that money is still owed and it is still due. It just cannot be the basis of an eviction. And starting March 1st of 2021, landlords can go to small claims court to recover any unpaid amount. Then there is the transition time period. So that's from September 1st to January 31st. Again, you have to make sure you turn in your declaration of COVID-related financial distress. And if you're a high-income earner, your documentation of income. But you also have to pay 25% of rent for each month in this period has to be paid by January 31st, 2021 to avoid eviction for the unpaid amount, the other 75%. So either the tenant can pay 25%, for September, October, November, December, January, that 5-month period. So you can pay it monthly, or you can make a lump sum payment before the end of January 2021 of 125% of 1 month's rent. Again, AB 3088 does not relieve you of your responsibility to pay rent. That other 75% is still owed. It is still due. The remaining amount 1st of 2021. If the tenant cannot pay the 25% of the rent, you're still protected from eviction until February 1st, 2021 for rent due during the transition period, because that payment has to be made before the end of January.
Ms. Gitasatani, if we can
Yes.
go back to that last slide again.
Okay.
So it's obviously quite clear that a person is protected from eviction during the time periods that are shown here for non-payment of rent, and that rent does become due after that. But it sounds like the implication of what you're saying is the person cannot be evicted for non-payment even after that period lapses without the landlord going to small claims court. They can't simply say, you need to pay up within X time frame, or you're going to be evicted. Their only remedy is small claims court.
So if it is rent from March 1st, 2020 through the end of January 2021, for that time period, they cannot be evicted for non-payment of rent during that time period. And yes, the only remedy would be to file a civil action in small claims court if it's not paid up by that time.
Okay, interesting.
Yeah.
Thank you.
We do have some best practices. So the declaration of COVID-related financial distress, you don't have the obligation for the tenant to turn it in, does not kick in until you receive a 15-day notice from your landlord. So your landlord would first serve you with a 15-day notice to pay rent or quit. You then submit your declaration of COVID-related financial distress to your landlord within those 15 days. So your options would be either, within those 15 days to either pay the rent, turn in your declaration, or, move out if you cannot, if you don't fall under, if you're not a covered person under the, under AB 3088. But we are recommending for tenants to turn in those declarations as soon as possible. So submit a declaration for each month through January 2021. Clearly indicate which month the declaration is for. 2021, turn in one declaration for that, and then do one for each of the other months, September, October, November, December, January. Turn it into your landlord. You have to submit, and then in addition, submit a signed declaration each time you are given a 15-day notice to pay rent or quit from your landlord. So just because you turned it in ahead of time, don't neglect to turn in another declaration if you are then served a 15-day notice. Keep careful records of all rent payments and any declaration given to your landlord of COVID-19 related financial distress. If you are making the required 25% payment towards rent that accrued during the transition time, clearly indicate on your payment which month it's for. If you are making a lump sum payment when possible, clearly indicate the month and amount the total payment covers. There is the other protection under AB 3088, which is that no cause evictions are not permitted until February 1st, 2021. That means notices to terminate tenancy for reasons other than non-payment of rent must have a just cause. So at the beginning of this year of 2020, California had a law, it was AB, I think 1482, that passed last year. So it went into effect at the beginning of 2020 that certain, most tenants, but there were, should get, when they are being evicted, their notice should include a just cause. And one of the limited reasons under the notice of why they are being evicted. But that protection has now applies to everybody, all residential tenants. So there are no more exceptions through, until February 1st, 2021. And so the way the law works is there are at-fault just causes and there are no-fault just causes. At-fault just causes include non-payment of rent, breach of a material lease term, nuisance, waste, failure to execute a similar new lease, criminal activity, denying a landlord entry, using the unit for unlawful purposes. Those are some examples of at-fault reasons. And then there are no-fault reasons. For example, owner move-in. And that must be a part of your lease if you've entered a lease after July 1st, 2020. Withdrawal of the unit from the rental market. Substantial repair or demolition to maintain compliance with applicable laws governing habitability. Or the owner has entered into a contract for sale of a single-family home or condo. The buyer intends to occupy the property, and the buyer is not a real estate investment trust corporation, LLC, with at least one corporate member. So now notices to terminate tenancy must include one of these limited just cause reasons to terminate a tenancy. So an overview, AB 3088 does not relieve a tenant to pay rent. It only delays that payment. It does not protect tenants who are unable to pay rent prior to March 1st of 2020 or for non-COVID-19 related financial distress. A landlord can still evict tenants for reasons other than non-payment of rent. Example, you violated your lease or owner move-in, but it cannot be in retaliation for not paying rent. I'm going to move on to the CDC moratorium. This went into effect September 4th of 2020, and it's going to last through the end of this month, the end of this year. It's a national eviction moratorium for virtually all tenants in the US impacted by the COVID-19 pandemic, and its intent was to prevent the further spread of COVID-19. It bans landlords from evicting tenants for non-payment of rent and non-exempt evictions through the end of this year if a tenant has submitted a declaration of income loss or significant medical expense. And it includes any action to remove or cause removal of a tenant for non-payment of rent, such as filing an unlawful detainer, staying an active unlawful detainer, and possibly staying lockouts. It applies to pre-COVID-19 cases, so even though it went into effect September 4th, 2020, it doesn't have a start date, it only has an end date. And it creates a floor of protections. It does not replace stronger state or local eviction protection. It does not relieve tenants of their obligation to pay rent. Rent would still be due after the expiration of the order. Oops, I got a little note that my internet might have gone out. Let me know if there are issues. It does not prevent eviction. Okay, good. It does not prevent eviction before January for certain reasons other than non-payment of rent, such as engaging in criminal activity while on the premises, threatening the health and safety of other residents, damaging or posing an immediate and significant risk of damage to property, violating any applicable building code, health ordinance, or similar regulation, relating to health and safety, or violating any other contractual obligation other than the timely payment of rent or similar. To be eligible under the CDC moratorium, a tenant has to be unable to pay the rent due to income loss or medical expenses. This one isn't as specific to COVID. It just says, due to income loss or medical expenses. Either expect to make less in 2020 than $99,000 individually or $198,000 as a family, or you have received a stimulus check, or you did not have to file a 2019 tax return. That you try or have tried to access any government rental assistance funds that may be available. You agree to make partial rent payments based on what you can afford. And if evicted, the tenant would be homeless or would have to move into a crowded or substandard living situation. Into one, whereas in order to be eligible under the CDC moratorium, all of this has to apply to you. So all of these bullet points. This is a copy of the declaration. I believe it's available on the CDC website. Pretty much has the bullet points that I had gone through. You are signing it under penalty of perjury. There are criminal penalties. So if a person violating the order may be subject to a fine of no more than $100,000, the violation doesn't result in death, or a year in jail or both, or a fine of no more than $250,000 if the violation results in death, or 1 year in jail or both, as otherwise provided by law. And the U.S. Department of Justice may initiate proceedings as appropriate, seeking imposition of these criminal penalties. Limits of the CDC order, it applies to every U.S. state and territory with a reported case of COVID-19. It does not apply if there is a moratorium on residential evictions that provides the same or greater level of public health protection than the requirements listed in this order. So it likely creates a floor of protections with local or state moratorium able to provide equal or greater protections. It does not replace or override stronger state or local eviction protections. And it does not cancel or stop the rent from being owed or stop the buildup of rent. I'm not going to go through all of these, but I do have some differences highlighted. If you're an eligible tenant who submits the declaration, you cannot be evicted for non-payment of rent in that covered time. The back owed rent becomes a consumer debt, and you can't be you can never be evicted. Can never be the basis for an eviction, and it applies to rent and other financial obligations under a lease, for example, utilities. Whereas the CDC moratorium, eligible tenants who submit their declaration cannot be evicted or removed from the home for non-payment of rent until the expiration of the moratorium. And it applies to non-payment of rent, late fees, interest, and no-fault evictions. Under AB 3088, tenants are required to make some payments. So, there's 2 time periods. For March 1st of 2020 through the end of August 2020, is actually required for the tenant. But then from September 1st through the end of January 2021, the tenant must pay 25% of total monthly rent for this period by January 31st, 2020. And then the CDC moratorium only requires tenants to make their best efforts to make timely partial payments that are as close to the full payment as the individual's circumstances may permit, taking into account other non-discretionary expenses. Under AB 3088, a tenant must submit the declaration within 15 days of receiving the 15-day notice to pay rent or quit. And again, those 15 days do not include weekends or court holidays. Whereas the CDC moratorium, there is no specific time limit, and it can be submitted anytime, the declaration. Under AB 3088, landlords can collect rent from eligible tenants who submit the declaration, or can't collect rent from eligible tenants who submit the declaration until March 1st, 2021, but then the landlord can pursue those claims in small claims court. There's no specific protection under the moratorium. Let's see. AB 3088 does stop no-cause evictions, but it does not stop evictions for reasons other than non-payment of rent, unless the tenant can affirmatively prove the landlord is evicting the tenant to retaliate against the tenant for rent, debt, unpaid due to COVID-19 related And so under AB 3088, a landlord is prohibited from acting upon a 15-day notice to pay rent or quit if the eligible tenant submits a hardship declaration, and it prohibits no-cause evictions. The CDC moratorium prohibits a landlord from taking any steps to evict a tenant, including moving an unlawful detainer action forward or seeking a writ of execution. All right, thank you. Please let me know if you have any questions. We do have our phone number on here if you have specific questions to your case. And again, you can go on our website where we do have a summary of both the AB 3088 and the CDC moratorium.
Great. Presentation, and I saw one hand, but before I just wanted to note I saw the additional context about why a landlord couldn't go after a tenant even after the protected time period closed for the back rent, and I saw that you explained that AB 3088 reclassifies that back owed rent as consumer debt, and that's the basis for it not being grounds for eviction after the protected time period. Thank you for that additional context. I saw Commissioner Evans.
Yes, and this is all towards the tenant, but I would really hate to be a landlord at this time because, you know, if you've got 8 months that you can't collect rent and you still have your mortgage and taxes and sewer and water, and I mean, who, because if he goes to the small claims court, I mean, if you haven't been paid in all that time, you can't expect that the tenant will be able to pay. You can't get blood from a turnip. So is there some help for them? I mean, I feel bad.
AB 3088, there are also protections for, I believe, homeowners. We do have a summary of that on our website. I didn't have information about that in our presentation. Many of our clients are not homeowners, so I'm not as familiar with those protections, but there are some protections for homeowners under AB 3088. And there were some moratorium on mortgages from the federal government and from the state. So there was help from other avenues.
Thank you. And may I ask you to stop sharing your screen? It will be helpful for us in moderation to be able to see everyone again.
Yes.
And also I wanted to, I really appreciate your comment and question, Commissioner Evans, and I wonder if staff, I know some of what you were describing is outside of the scope of services of the Legal Aid Society, but still a critical issue for Carlsbad residents and owners. And I wonder if staff is aware of or could comment on any programs either for rent forgiveness for people who simply aren't going to be able to make up that debt they've accumulated, or for landowners.
Commissioners, this is Robert Chambers. Our live stream just died. I'm going to go ahead and restart the live stream when I can, but it'll probably take me about 2 minutes. My apologies for the interruption.
So I'll continue with the question just to set it up so that once we're back live, you guys can answer, or let me know if we don't have much of an answer and I won't put you on the spot. I know that especially at the beginning of the COVID pandemic, we would hear in the news about how different government entities would provide various mechanisms to support landlords for exactly the reason Commissioner Evans just described, that, you know, it helps renters to be protected, but if the landlord goes bankrupt, that ultimately can have more long-term consequences. Or rent forgiveness for people who just never are going to be able to make up that debt. Are you guys aware of any programs, and in particular, did Carlsbad enact particular programs or protections?
So I can answer that question, but I think we should wait
Sure.
to go
We don't
back.
need the answer now. I just wanted to make sure I set it up so that once we're live.
Good.
And so you had a moment to think about it, look up anything you needed to, or to let me know that we don't have an answer and don't put us on the spot. So when we do come back live, I'll restate my question more briefly, just because I don't know where it cut out in the midst of it.
Commissioners, this is Robert Chambers. We are restarting the broadcast. And we're up.
Great, thank you. at the beginning of the COVID pandemic, there was news of a variety of government agencies at different levels aiming to address just the issues that Commissioner Evans raised, both about the loss of income to landlords and the impact on them and small businesses, and also for renters, if perhaps they were covered by this protection, but the loss of income meant that they were never going to be able to recover the funds necessary to pay that debt. Are staff aware of any of these programs at any government levels in California that affect Carlsbad residents, and in particular, anything that Carlsbad took action on?
Yes, yes.
So in terms of the mortgage forbearance programs, does have CARES Act funding dedicated to that. The specifics of that program, I don't have the particulars of. In terms of rental assistance for those impacted by COVID, the city does have a CDBG funded program for those impacted by COVID. Funding is provided for clients, residents, Carlsbad residents, up to $4,500 for back rent as well as future rent. Residents need to income qualify for those grants. In terms of other funding available, Dave, do you want to have anything to include?
I did want to point out, however, that we do have information on the city's website regarding our emergency rental assistance program. It's being administered by two organizations currently, the Community Resource Center, as well as Interfaith Community Services. So for anyone that is having difficulty with their rent due to COVID-19, we encourage them to apply to one of those agencies. And again, there is information on the city's website on how to contact those agencies. What I would do is go on the city's website and then type in affordable housing, and it should to the webpage that has information on that. In addition to that, there is information. We link to the state of California's website that does provide lots of information about assistance to and protections to landlords and tenants and homeowners as well. So currently, the primary program that the city of Carlsbad has is the rental assistance program. And next month, the council will be potentially considering expanding that program further.
Great, thank you. That's important information. Thank you for sharing that.
Okay.
Any commissioners have further questions about the presentation?
I was just going to mention something. Yes, again, Legal Aid had a wonderful presentation. Thank you. A lot of you don't know I used to work for Legal Aid.
Oh.
And so I love what they do. And prior to me working for Legal Aid, when my son was dying, I spoke to an attorney, but at that time I did not qualify to get help from Legal Aid. But the attorney was very good to me and told me exactly what I had to do. And because of her, and I always will remember her. And it was, oh God, I just lost her name, Rosemary. It was a and I forget her last name. But anyways, what I was going to mention was I do know a couple people that got help with the COVID-19 that are homeowners. One was they have their mortgage with Penny Mac. They help with the COVID. Also, Chase Bank helped with COVID for homeowners that were impacted by COVID. So, and then there is a under 211, but you can also go, I was sent email, and I'll forward it to you guys as well, that it gives all information on where people can get financial help, different things, addiction. It's just a big old communication website where you can get all the information for that. And I do know though for a fact that on the help for the people needing help, 4,500 that she had mentioned, it does not help people on Section 8 though. because it's part of the contract that you must pay your rent. So if you are on Section 8, there's no there. Section 8, you must pay your rent. And if you're getting in trouble where you're losing your job or anything like that, then you need to go to your housing specialist and let them know. So that's all. Thank you.
Thank you. That was a lot more information and context. That's wonderful. Thank you for adding that. Any other commissioners with additional comments, question, or information to share? Seeing none, then I'd just like to, again, as others have said, reiterate our thanks to Legal Aid Society of San Diego, not just, of course, for your presentation tonight, but for your representation and services to Carlsbad residents. To have nearly 200 residents a year served by you is really important and a testament to your value to Carlsbad. Thank you. We'll move next to, I'm sorry, I should ask, was there any additional public comment that came in during the course of the discussion and presentation before I move on?
No, there is no comments.
Okay.
No comments.
Thanks very much. So we'll move to the agenda item, which is our meeting calendar for 2021. Everyone received the draft, but we have already an addition to that schedule. So I'll turn this item over to Mr. De Cordova.
Thank you, Mr. Chair. So this item is to formally adopt the meeting calendar for next year, for 2021. And we would, as the calendar indicates, the commission would continue to meet on the second Thursday of each month. And but I did want to take, one change here because of the ongoing COVID emergency. The draft here would have those regular meetings starting at 4 p.m. Rather than the historic 6 p.m. start time. So that would be something I wanted to make sure that the commission was aware of and point that out and make sure that that is amenable to all. And then the other thing that I wanted to bring to the Housing Commission's attention, as you all know, last week you did meet to discuss the draft housing element. And on Monday, the Housing Element Advisory Committee will consider the version of the draft housing element to send up to the state for their review. Has concluded, then staff will begin the final revisions to the draft and then the formal public hearing process. Because we are on such a tight timeline, meaning that under state law, the city council would have to adopt the new housing element by April 15th of next year. We are under a tight time frame to have the Housing Commission and Planning Commissions do their public hearings, review of the final document, and then their recommendation to the City Council. So having said that, team is looking at a potential special meeting of the Housing Commission on Thursday, March 3rd, beginning at 6 p.m. For the purpose of having the public hearing on the housing element. So
March 3rd is a Wednesday, by the way.
Oh, it is.
Do we know if the date is correct or if it should be Thursday the 4th?
Let me double check that. Okay, well, I stand corrected. March 4th it is. It would be on the off Thursday. Yeah, first Thursday.
And would we, are we inviting this to be an amendment to the staff report in place of March 11th? Or would we treat that as a special meeting and keep the meeting on 11th and give notice of cancellation if we didn't have sufficient business.
Right. I would suggest that we keep the calendar as it's presented and treat the March 4th meeting as a special meeting, so that we will need to get confirmation that that schedule is going to hold, and we will provide that notice, as we get closer to that date. So I think it would be best to keep that as a special meeting. And then the other piece to that is that the team would ask the commission to think about whether or look at potential availability for a follow-up meeting on Monday, March 8th. If for some reason the commission is unable to get through the review of the housing element on March 4th. So that date should be a Monday. Yep, it's a Monday. And that would start at 4 p.m. So we don't need to change the calendar. Make sure the commission was aware, and so that they can hopefully check this, see if you are all available on those potential dates.
Great, thank you. Is there any commissioner who has reviewed all of these dates in advance of tonight's meeting and would like to address any known conflict at this time? Seeing none, is there a motion to approve the calendar?
Aye.
Vice Chair Cortez Torres moves. Is there a second?
No second.
Commissioner Evans seconds. All those in favor, please say aye.
Aye.
Aye. Any opposed? Any abstentions? So that was unanimous in support. Great, thank you for that, and thank you for the heads up about the Housing Element Advisory Committee meeting. Or I'm sorry, I shouldn't say the committee meeting, the consideration of the housing element. The committee meeting that is being held though this coming Monday, may we request that the commissioners be mailed that public draft? I guess we're still calling that the, I forget on his chart, we're not allowed to say public draft. The HCD draft, I think it's going to be called at that point. The Housing and the State of California HCD draft coming, that'll be under consideration that evening.
Yeah, that is correct. So was it, could you repeat? Mailed or mailed?
Yes.
To the commission?
Yeah, just the document that's emailed to the committee for their consideration that evening, if we can have that emailed to our commission in advance as well.
Yeah, absolutely.
Certainly, Commissioner Evans is our representative on that body and attuned to everything they're doing. But considering as well that this is the meeting at which they will take they will give a recommendation for submission to the state. Any other commissioners who are interested, I would encourage you to join that meeting as a member of the public. Okay. Housing Commissioner comments. I have just one myself just to share with all of you, because the housing element, once it's to help maintain and ensure its continued implementation over the subsequent 8 years, I thought I would mention that I had a meeting today with our city's community development director, Jeff Murphy, to talk about certain elements or certain items within the housing element and other ideas that have arisen. The thing that we always want to be mindful of is that the housing element is a guiding document, and so whatever is adopted, we are obligated to explore or take action on as a city, but it does not preclude us from taking action on anything that isn't within that document in the future. And so to the extent that there are items that have been discussed about housing policy before, the idea of finding ways to better support employer provided housing and whether zoning changes are necessary for that. There may be a variety of ideas that have come up in discussion, and will be great for us to explore in the future, but may or may not make it into this document. So the document that will be presented for final consideration by the Housing Element Advisory Committee, understand that it is not a limiting document, but it absolutely is a guiding document for the city. And I would just encourage our continued discussion about all those housing policy items. Any other commissioners have updates or comments on any meetings or events relevant to our business?
I was just going to mention again that website, it's sandiegocounty.gov. So if you type in sandiegocounty.gov, it'll give you a lot of information of the help that's available.
Great, thank you. And you mean for the COVID pandemic?
COVID and a lot of other information, yes. But especially COVID, yes.
Thank you. And we'll move to our Housing Services Manager comments.
Thank you, Mr. Chair. I have just two announcements. And as I mentioned a short time ago, the Housing Element Advisory Committee will hold their what will be their final meeting on the housing element update, and we as staff will be requesting that they give direction to go ahead and forward the revised draft up to HCD to initiate that review process. So that meeting will be held on Monday at 3 p.m. I believe, and we will make sure that all of the housing commissioners do get a copy of that revised element once it's made available. And then just another note. So on Tuesday, the City Council reviewed the affordable housing resale guidelines that the Commission reviewed. I think it was back in August, and they did. And as well as the supporting policy that provides guidance to staff on when to acquire existing affordable housing units, and then for the disposition of them. So the council did approve the guidelines as presented and as recommended by the Housing Commission, with one exception. So as you'll recall, the Housing Commission did request that the council consider a local North County type residence preference for applicants of the city-owned units, and the council did not approve that that consideration. There were concerns about fair housing implications, and so instead, what the council went with was the base requirement that an applicant must be a San Diego County resident. Everything else was approved as recommended by the commission.
Great, thank you for the update.
Okay.
Yeah, I'm happy about that.
And if there's nothing further, I just want to close on a note of thanks to Commissioner Evans for being our representative on the Housing Element Advisory Committee. It's been a massive amount of work, a whole lot of meetings throughout sort of an extraordinary time in America right now with the shutdowns and navigating technology and everything else involved. So just thank you, Commissioner Evans.
Oh, thank you, John.
Yes, and
Appreciate
on
it.
behalf of staff, I really thank you as well.
Thank you.
With that, we're adjourned. Thank you all for joining this evening.
Thank you.
See you next
Thank
time.
Thank you.
Good night.
Patty and David, thank you. Hi.
Thank you.